Welcome to Break the Needle. I'm your host, Adam Zivo, and I'm here to tackle Canada's problems with addiction and crime. Today, we're going to discuss how Canada's judiciary enables the national overdose crisis. Joining us here today to tackle this issue is Jamie Sarkonak, a columnist and editor at the National Post who leverages her legal education to investigate judicial activism. Welcome to the show, Jamie.
Hi, Adam. Thanks for having me.
Now, just to establish the context here, can you quickly summarize the judiciary's role in the criminal justice system and how its powers interplay with those of democratically elected legislators?
Well, the judiciary is the bench of judges. There are a few different levels of them, but basically their job is to apply the law as it was written by the legislators. So, whenever we outlaw a certain thing, it's up to the judges to actually make sure that gets put into practice. So, putting people in jail, for example, for breaking the law.
But just to clarify for our viewers, laws are often written in a way that gives judges a great deal of discretion in terms of what kind of penalties are applied to criminals. Is that correct?
Well, yeah, exactly. And there's also the law that's called the Charter that overrides really anything in that Parliament passes, for example. So, if a law passed by Parliament is viewed by the judges to go beyond the bounds of your rights that are set out in the Charter, they can strike it down. For example, mandatory minimum sentences. So,
Mhm.
a lot of the time, those end up getting struck down because the judges say, well, there was, they'll imagine a scenario that's different from the one that's before them, and they'll say, it would be unfair to give the mandatory minimum sentence to this person, given these imaginary set of facts. So
Mhm.
we are going to strike down this minimum sentence.
So we're going to get to the charter later in this episode, but for now, I want to focus on the fact that you've argued how Canadian judges are too lenient with drug sentencing. What do you mean by this?
Well, judges get a lot of discretion in laying out a sentence. It can happen with drug related charges, also violence, a lot of egregious violence charges. With with drugs, yes, sentencing is one element of it. You can have drug dealers who come across the border with all sorts of stuff loaded into their vehicle that they shouldn't have. And there are mandatory minimums that deal with that. But a lot of the time, people want bigger sentences for major drug traffickers, and they don't see it happening. And so that's just a matter of the judge's sentencing brain not being calibrated with the morality of the general population. But beyond that, there's also just an issue with criminal procedure. You know, judges throwing out evidence because they'll say that a search of a individual was not lawfully conducted. Um, and sometimes very anti-police type judges will say they'll actually apply almost a model of perfection onto the judge and say, or onto the police and say, you didn't meet that. So we're going to throw out this piece of evidence, and that evidence was crucial to getting the conviction. So on top of the sentences not being very aligned with what people would want to see, a lot of charges don't make it all the way through the system and get dropped long before then. So that's also a big problem.
So, if the problem partially is that judges aren't aligned with the morality of the general population, what's the solution here? What are our options to ensure that the judiciary better reflects the beliefs of Canadians?
Well, one is appoint better judges. Some people will say maybe we should elect the judges, but I would say people aren't happy right now with Parliament, and that's an elected system. But a lot of these judges, for example, that are dealing with drug charges at small levels are provincially appointed. Conservative governments right now could be appointing harsher judges. And some of them are. There has been some improvement, but it's not where people would like it to be because everyone is always getting outraged at the latest piece of news that comes down from the courts about some guy getting a lenient sentence. So appointing better judges who are more aligned with what the public wants, but also when a law is struck down for, again, what the public would say ridiculous reasons, you can invoke the notwithstanding clause and say, okay, judges, you said this went against the charter, but we are going to put our law back and say we're going to just override the charter. We're going to put our own view of what rights should be in Canada on
Mhm.
top of that,
Now,
and
Jamie,
the law will stand.
When we get back from the break, we'll talk more about the Charter, the Notwithstanding Clause, and how these two elements interact with the addiction world in Canada. And we're back with National Post columnist and editor Jamie Sarkonak. Now, Jamie, in recent years, we've seen a rise in judicial rulings that broadly interpret Canada's Charter of Rights and Freedoms to protect addicts and public drug use. Can you give us a few examples of this and explain the context of these rulings?
Well, one I would say is the encampment situation. Now, this doesn't apply in Alberta because in Alberta we said you can clear the encampments. But in places like BC, Ontario, legislatures have run into problems trying to clear these camps. And encampments aren't directly a drug issue, but let's be real, most of the time, lots of drug use is happening in these camps. And the drug use is part of why these people are homeless to begin with. Um, but what the courts have said in those situations is that you can't clear a camp unless a whole bunch of space that could accommodate these people in shelters is available, and logistically that's quite hard to meet. And with the volume of homeless people in these camps, that can be again very difficult to meet. So what ultimately ends up happening is the courts say, no, you can't clear this camp in this park, and the camp will remain there. And now the public is deprived of using that park because we have to deal with this new, I guess, new form of property rights, really, because we're saying that even though it's not yours, this piece of public space is now yours. We can't evict you from it.
Hmm.
So that would be one.
Well, what's interesting is I actually wrote about some of these cases as well. And there was one particularly egregious case in Ontario where a Superior Court judge ruled that the city of Waterloo wasn't permitted to evict encampments unless they could provide shelter spaces for every resident of these encampments. But these shelter spaces had to be accessible, and accessibility was defined as permitting open drug use. So essentially, he was trying to use this case to force the city to allow open drug use in shelters, even though that's something that should be debated amongst democratically elected legislators and is really a form of judicial activism for him to try to enforce. Now, I'm wondering, what are some of the underlying issues that enable forms of judicial activism like the ones that we've been discussing in this episode?
Um, at a broad level, it comes down to Canada's legal culture, and there's the judicial culture, which is sort of in that. It's a subset of that, but it's largely progressive leaning. You know, the law schools are largely progressive leaning. Um, the training sessions they set up for judges are progressive leaning. There are a number of those. And when it comes to
Mhm.
drugs, there aren't any, it's not legislated by the federal government, for example. And like there's other kinds of training regarding social issues that they do require. So drugs would not be part of that. But a lot of the time it works its way in anyways. Um, and then there are also just the positions of the courts themselves. A lot of places are trying to set up drug treatment courts, which could be a very good thing to put people into treatment. But sometimes in practice, they end up just being more lenient to drug users and allowing this to continue. So
Mhm.
that culture really permits this kind of thinking, and it's very detached again from the broader population.
Now,
But
Jamie, you said
judges are
that,
a rather isolated bunch.
well, you said, for example, law schools and training sessions tend to be progressive leaning. What does that look like in practice? If you can just sketch that out for us.
Well, it's professors who uh, talk about how jail sentences aren't really the solution, how it perpetuates more crime. There's a cycle of poverty. You'll have lawyers coming in to do talks, and this is in legal circles or just law schools. Um, and they will talk about how there's a cycle of poverty, and we need to be more sensitive to this, and that harsh sentences can just descend someone further into this cycle. And that can be true, but a lot of the time there isn't a competing narrative offered to say, no, but there is a good reason to take certain individuals off of the streets for a long time. Um, and again, there seems to be a culture of everyone can be rehabilitated. If you actually go into these camps or if you talk to people who work directly with it and aren't imbued in that ideology, they'll say, no, there are people who are so far gone that they're just going to commit violence. They're just permanently hooked on these drugs. They either need permanent treatment or something because it's just going to be
Hmm.
more destruction for them on the street and it's going to be terrible, bad
Yep.
for the individual as well.
And there seems to be an underlying issue where the conversations being had in law schools and in these training sessions are preoccupied with the rights of criminals and addicts without considering the broader societal impacts. Where are the considerations of public safety? What about the people who are impacted by the violence committed by these individuals? Now, when we get back from the break, we'll move on to the immigration aspect of this debate. And we're back with National Post columnist Jamie Sarkonak, who often uses her legal education to investigate judicial activism. Now, earlier in our conversation, we looked at how lenient sentencing and misuse of the Canadian Charter of Rights and Freedoms allows criminals to evade accountability. But we know that these same dynamics play out in our immigration system as well. Now, Jamie, from my understanding, there are judges who have blocked the deportation of drug dealers and allowed them to stay within the country where they can presumably continue preying upon vulnerable Canadians. Can you tell us more about these dynamics?
Yeah, well, first of all, at a high level, uh, people, I think, generally think that committing a crime would get you deported from Canada, and you would sort of be correct because on the books, committing a crime diverts you into the deportation process. But sentences under a certain level, I believe it's 6 months, don't really they're harder to deport, I guess is the easy way to put it. And over 6 months, um, they're easier to deport, but oftentimes even that isn't enough. Now, getting into the actual deportation process, what judges will do is they'll get a case before them and they'll evaluate the individual. Their lawyer will put forth arguments as to why they should stay here. They'll say, well, this person deserves a fair shot at rehabilitation. This was a case, I covered one recently. It was a guy from the Philippines, and he had actually been convicted of ramming a police car with his vehicle. That's quite serious because you're interfering with an officer. And on top of that, he had a history of drug addiction, which is sort of where all of this came from. And when he got to the deportation court or the immigration decision maker, they said, well, in the Philippines, they are harsh on drug users and addicts, and this guy's in treatment, and he seems to be doing well in treatment, so we're not going to send him back to the Philippines because that could interfere with his rehabilitation. And so, presumably, he's still here. It's hard to actually find the fate of these cases because that's all covered by privacy. But ultimately, his deportation was canceled over that. But you know how these cycles repeat and repeat and repeat. Maybe in that day he was doing well, but he very well could have slipped back into it, or whatnot. Um,
Mhm.
and then there was another case that I covered out of Trinidad, and the individual had a large list of charges behind him. It was over 30, and they were violent, and they had to do with drugs too. And not an individual that we need in Canada. He was slated for deportation, but um, even though the judge said that he had a low chance of rehabilitation and he seemed to have no remorse. He was not a good candidate for staying in Canada. The judge said, we'll let him stay just in case because he deserves a shot at showing that he can stay, even though we've had a bunch of criminal proceedings already showing that he has violated our deepest held rules. No, we're still going to give him another chance to stay.
Mhm.
So that's how that goes in real life.
And how is this allowed? And is there any solution that could stop this kind of misuse of judicial discretion from being applied?
What we need is a stronger law in the back end because right now we give these immigration tribunal adjudicators and then above that federal court judges, they have a lot of discretion in calling these guys off of the plains, so to speak. Um, they're able to halt these proceedings just on the basis of, well, I think he might change this around in Canada if we give him a few more years.
Mhm.
And I
And then just
found numerous cases where they don't actually turn it around. So you just need to legislate, because right now it's not legislated. Right now it's a system of you guys can do that, and what we need to do is write it into law that the judges cannot do that.
and just very quickly in the last 20 seconds, what about asylum? Do we see any indication that drug traffickers are misusing the asylum system to stay in Canada?
Um, there have been cases where organized crime is totally abusing the asylum system to bring people in, because we'll just approve them, and then they'll get to stay here for how many years while their case is being adjudicated.
Okay, so we have a system in place where if you are caught trafficking drugs, you can simply claim asylum and you can stay for several years while your claim is sorted out, at which point you are more or less free to continue trafficking drugs and harming other Canadians in your immediate vicinity. That's pretty concerning. When we get back from our break, we'll go a bit more into those dynamics and we'll look at a few key takeaways that Jamie can share with us. Thanks for joining us. Now, before we went to break, we briefly covered the issue of asylum and the fact that organized criminals will claim asylum in order to avoid deportation. And of course, organized crime often intersects with drug trafficking, so it appears that the asylum system shields drug traffickers from true accountability. Now, you said that there were some cases of people claiming asylum. Can you run us through how this all works? And how is it that our system is so vulnerable to abuse?
Well, there was a case out of BC recently where I believe they were involved in extortion, but again, it's the organized crime network, so it's very likely they're involved in drugs too, which the whole case wasn't put to the public. But what happened was they were caught in an extortion sting, and then they claimed asylum when the charges were pending. When they caught wind that they were under investigation, they claimed asylum, and then that started the process going for them. So, and then how it works from there, I mean, they have to work their way through the claims process. They get their whole application gets evaluated. But again, because there are so many people lined up in this queue, it can take a long time. There are shortcuts around it, but as to whether the refugee authorities or the immigration authorities, whether they'll take them is unclear, because we have a very unambitious immigration minister who seems to be quite out of her depth in handling these problems.
Mhm.
All of
And
these sorts of criminal cases get put to them.
for clarification, while someone's refugee asylum claim is being reviewed, what level of support do they receive from the government? What social benefits can they access?
Oh, they receive free healthcare, free dental care, free eye care. Even if their claim is rejected, there's a period of time where they're still covered. Or if their claim is rejected at one level, they get to hang out in Canada while they appeal that, and they'll still get coverage in that time.
Mhm.
So it's a quite generous system. And then there are also housing benefits and various other supports we give them as well. So it is quite generous.
Okay, so for drug traffickers who foreign drug traffickers who come to Canada and sell poison to our citizens, rather than showing them the door, we give them free dental care and free housing. It seems a little bit broken. Now, I'm wondering in the last 2 minutes that we have here, if you could just give us a rundown for what you think are the most important legal reforms that could be implemented uh, in the near term, if there were political will, to help bring our system back to some semblance of sanity.
Well, one, I'll go back to appoint judges that believe in protecting the public and that aren't sucked into a bubble of we just need to give people infinite chances to prove that they can live a drug-free life and not hurt people. So that's a big one. That takes a lot of time though for that to really come around and start to affect the system. So on top of that, legal reforms that assist getting these charges over the line. um, here's an example. The Good Samaritan Act. That's not the official law's name, but there is a law on the books right now that it allows people who are calling paramedics for a drug overdose situation to have immunity from charges stemming from that interaction. And This is to encourage overdosers to get help and not have them die because they're afraid of getting a drug charge. But this has been used now to kill serious gun charges, and that's not good either. So um, that law can be abused then by organized crime because it can blanket out more serious charges that don't have to do with simple possession. It's not my friend overdosing at a party, it's my friend's sawed off shotgun that's getting excused in the courts.
Mhm.
Um, and then just overall, an attitude of we're going to get this done. Whenever a mandatory minimum gets shot down by the courts or whenever a ridiculous ruling comes up, provincial governments, provincial justice ministers need to be appealing ridiculous decisions and saying we're going to
Mhm.
appeal this because we can't let this stand.
And sometimes the solution just seems to be to use the notwithstanding clause to ensure that these human rights that are developed by the charter in a sort of strange way are overruled. Thank you for joining us on the show today.
Thank you for having me.
We often believe that our judges will protect our interests and keep us safe. But what happens when they fail in that responsibility?